firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, thank you very much for sticking around. It's the community on the law, and we're back with you. A few technical issues here, so we have delayed a bit, but definitely it's better late than never, isn't it? With all excitement, I'm going to let you into what we're going to have to discuss this afternoon. We're looking at children and British nationality, a pathway to automatic citizenship, and how to navigate that process. It's the 20th of July, 2024. My name is Oreku Frimpong. Now, earlier on in the week, we had our sponsors and our benefactors, BWF Solicitors, our trusted partners when it comes to the law, give us things that we can chew on and also know to be on the right side of the law. The nugget was thrown at us earlier in the week. Overseas domestic workers here in the UK. Now, this domestic worker visa admits domestic staff working in a private household to enter the UK and continue their employment in the UK for up to 6 months. This visa is suitable for domestic workers in circumstances where their employer or their employer's family members do not intend to remain in the UK for more than 6 months. It covers cleaners, chauffeurs, chefs, personal carers, nannies, and the like. These services must be for the employer or their family members. We get this from the Immigration Rules Appendix, Domestic Workers in a Private Household. We'll be getting the lawyers to give us some clarity on this one. So does it mean that if I have people who are serving me as cleaners, chauffeurs, or drivers, as we would call them, chefs, people who cook for us, personal carers, nannies, adults who take care of our children whilst we are away at work. Now, these people, can we bring them along with us here in the UK to really take care of the things that they were taking care of back in Ghana? The law says these services must be for the employer or their family members. And it's taken, as I said earlier on, from Immigration Rules Appendix, Domestic Workers in a Private Household. If you want further details, just give BWF Solicitors a call on 0208 493 7340. Our guest and our resource person this afternoon, Lawyer Charles Asma, is going to help us unravel this. And there was an issue that somebody wanted us to clarify, and we will look at that again. It's about whether when you marry somebody here in the UK and you have a child, who is the father of the child, who is required to be on the birth certificate and all those details. When we have time, we'll get lawyer Charles Asma to look at that. But in the meantime, I would want to also throw at you the question that we will be looking at during our quick segment. Now, this afternoon, my dear little sister, Pamela has put this question out, and I'm going to let you in on that so that you chew on it. And later on, when we come, we look at it again and see what answers you would have. Nana Etikopo is a driver at Kwesi Cashman's house in Accra. He's worked for Kwesi's family for 13 months. Adra Mary is Nana's wife. She also worked for Kwesi's wife as a nanny for 3 years. Kwesi wants to travel with both of them to the UK as one of his employees. How can they obtain a successful visa? 3 options here. 1, apply as Kwesi's employees as they have worked for more than 12 months. 2, apply as a tourist to visit the UK. Or Kwesi must show that he will pay them the minimum wage and also provide a contract of employment that complies with UK laws for their duration in the UK. Now, this gives us the conundrum to really go over to the desk of the lawyers from BWF Solicitors to help us unravel that, and that will help you answer the thing that is facing Kwesi Atikopo when he wants to bring his driver Kwesi Cashman and Adra Mary, Kwesi Cashman's wife, to the UK to work for him. This is the community and the law. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you very much for sticking around and helping us get into your homes, your environment, and also into your space. BWF Solicitors are trusted partners when it comes to the law. It's located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. Call them and book an appointment, go to see them, and enjoy the services they provide. 0208 493 7340. I repeat the number 0208 493 7340. Or the emergency number 077 127 61884. 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. Now, this afternoon, as I mentioned, we're looking at the pathway to get British citizenship for your young children, or your children, if I should put it that way. But before that, there's this law that says that you can bring your domestic workers with you from outside of the UK to do that. And I mentioned that Lawyer Charles Osma, our resource person and guest this afternoon, is going to help us look at that. So I read that again and then do the introduction, get him on. Then we get straight into that discussion and explanation. This domestic worker visa admits domestic staff working in a private household to enter the UK and continue their employment in the UK for up to 6 months. This visa is suitable for domestic workers in circumstances where the employer or the employer's family members do not intend to remain in the UK for more than 6 months. What does it cover? Cleaners, chauffeurs, chefs, personal carers, and nannies. These services, as it said, must be for the employer or their family members. Quoted from the Domestic Workers in a Private Household in the Immigration Rules Appendix. Ladies and gentlemen, with this, I have the honor and the duty to introduce our resource person and guest for this afternoon's Community on the Law. Live on BWTV, we're live on Facebook, YouTube, and all the other social media platforms. Lawyer Charles Asma from BWF Solicitors. Uncle Charles, good afternoon.
Good afternoon.
Yeah, thank you for joining us, and we appreciate your time. Now, I'll allow you to do your greetings, and obviously, tradition cannot be broken. So, ladies and gentlemen, I present to you Lawyer Charles Asma.
Hello, ladies and gentlemen, viewers, listeners, cherished patriots. Thank you very much for this engagement. Once again, thank you for your time. This afternoon's conversation is very, very important because it touches the core and the heart of immigration applications, especially for children. And it will interest you to know that there's something called automatism in law, immigration law, and that's what we are going to talk about, and that will favor your child, and you have to listen. So we'll not waste much time. I'll hand you over to my host.
Well, thank you very much. And he loves that tradition, so definitely I do not have to deny him of that. Now, if you have just joined us live on Facebook, YouTube, just leave your presence and your comments in the comment section down below, and click and like the page. Put a comment on there, as I mentioned earlier on, and pick up the link and share with your friends so that they can enjoy the tons of knowledge and experience we're going to have this afternoon from BWF Solicitors live on BWTV. Uncle Charles Asma, let me delve straight into it. I read a nugget that you guys put out earlier in the week, and it's talking about domestic workers that are allowed to be brought here in the UK. It's talking about cleaners, chauffeurs, chefs, personal carers, nannies, who can be brought from outside of the UK to join us here in the UK. First of all, I'll ask that what is this? Is this a new thing that has been introduced, or has been there, except that probably we have not paid attention to it?
So it's one of the opportunities created for, I know we have skilled workers, gateway, we have this and we have that. And this is another opportunity that the government has created for people. This is quite unique in that it's about individuals who are serving their masters in their home countries. If I say masters, we are talking about domestic workers, who will be tempted to call them domestic servants, but the law calls them domestic workers.
Right.
And they are itemized as cleaners, so people who clean your homes, doing your laundry for you, looking after your children, nannies, those who drive you, drivers or chauffeurs, those who are doing your personal cleaning or personal care. So there are individuals who are supporting the care of, for example, parents who are old, and therefore we have hired somebody to care for them in the home. So technically, let's call them maid servants.
Okay.
So this range of maid servants, the law has created opportunity for them, in that if your maid is with you and you are traveling to the UK, you can travel with them so that they come and serve you as they serve you at home.
Okay.
Not just you. If you've hired them to serve your family members, and those family members are traveling to the UK, they can travel with them to continue the job they do for them.
Okay.
And I think it's fair, because if you've hired them to do a job, and for a certain period, the law says 6 months, they are not going to be working because the person they are looking after or serving has traveled to the UK, it makes sense that they follow them to come and continue to serve them.
Okay.
And when they go back with them. So it's not a permanent route to UK settlement, but more or less opportunity for those people who want to travel to the UK with their masters to do that. But the question is, the law defines the master as employer. So the master is the employer. And if you are the employer, you have to show that you have employed the person.
So in this case, what do I need to show? What evidence do I need to provide?
So if you show so bring back the nugget, and there are key things we want to pick out. So it says that a household to enter the UK and continue their employment in the UK for up to 6 months. So you can't go beyond 6 months. Somebody will say if it's 6 months, then that's visitor's visa, because visitors also can be here for 6 months. The difference between this and visitor's visa is that a visitor cannot work, but this person can work. But they cannot work for another person. They will work for the same master or employer whom they were serving in the country they were living with them.
Okay.
The next thing is that there must be an employment contract. So that employment contract must sit well within the UK employment law. So we'll talk about duration of the employment.
Right.
We'll talk about the wage, and the wage must be within the minimum wage, UK minimum wage, under the National Minimum Wage Act 1998. Again, we're looking at the fact that if the employment contract is given to them, it has to show that if they are traveling abroad with them to serve them, visa fee, ticket, and all those costs relating to that travel will be paid for by the employer.
Okay.
So you can call it extra cost to the employer, because if not for traveling to serve the employer, this cost will not be necessary.
Okay.
So if they pay this themselves, then they have not met the criteria. And the employer must show this in the employment contract, that they are going to do all that. So if the contract is not set out, showing all the things we have indicated, then it will be difficult for the person to show that they are working for the master.
I envisage a scenario where back in Ghana, for instance, or back outside the UK in most developing countries, the people go in for house helps and there's no written contract. They go and ask the permission from their parents or from people who would be responsible for them and say, okay, I want this person to work for me in the big cities. There's an opportunity for that person to travel along with the employer, and there's no written contract. How do I prove that I have this person in my employment, and again, I'm traveling with that person and I need these things to show?
So the law says should. So nobody knows that you don't have it until you tell them that you don't have it.
Okay.
So if they've asked you to provide it for the purposes of the visa, all you do is to show.
Mm-hmm.
So at that point, it's a common sense thing. So you have to make sure that even if you have put it somewhere, you go and retrieve it. Signed, indicating all those items.
Okay.
And of course, you're not going to tell them that I've just put it together because I had not done it. Because we know that it's a contract.
It's a contract you need to have.
And therefore, now that you know that a contract must be in place, you make sure that it's in place so that it will be part of the visa documentation for that domestic worker.
Okay. Now, I have obtained a visa to stay in the UK for 2.5 years on the various routes we have. But prior to me coming, I had such a person in my employment back home. Can I ask the person to stay with me for 6 months and probably renew it later on because I am going to live here for at least 2.5 years?
Well, that's a good point. But the law says that. So if you go back to the nugget, very important, and continues their employment in the UK for up to 6 months. For up to 6 months. What it means is that it can be renewed, but renewed at source.
Where would the source be?
Well, so the source will be that depending on the circumstance. If after the period of being in the UK for 6 months, they go back to the home country, come back, because that person is not technically coming to live in the UK.
Coming to do a job and go? Or
no, they are coming, let's say it's you coming on holiday for 6 months.
Okay.
Let's say you have your 2 years visa, visitor's visa. But that domestic worker cannot come as a visitor and work for you. So they must come with their visa to work for you. And because you are the employer, you give them the necessary documentation so that they apply for domestic workers visa for you to come and serve you.
Okay.
So even though you have your visitor's visa, they have the right to work for you within that appendix provision. Now that you are here, because if you are here as a visitor, mind you, if you are here as a visitor, obviously you go back because you have to live 6 months and go back. So you go back and come back. So anytime you are coming back, they will come with you, but they have to renew that visa.
Okay.
If for any reason there is reason for you to extend your stay, then automatically you have to ensure that their stay is extended for the purposes of your bit that has happened.
So you need to prove that you have employed them. You need to have that in the contract that all incidental costs that may include traveling outside of the country with you should be included. That if there is a need for you to travel outside of your country, you will take them with you. And then that employment here in the UK, them coming to serve you as they were serving you back home, should not be more than 6 months.
So the visa they get will be up to 6 months.
Up to 6 months. Now I have a question, and that question I will not put it to you, but I'm going to put it out to my viewers and my clients. And what the question is, I'm going to put a scenario in front of you. Kwesi is a whatever Tikopo is Nana Tikopo is a driver at Kwesi Cashman's house in Accra. Okay, based on that discussion, listen to this very carefully. He has worked for Kwesi's family for 13 months. That is 1 year and a month. Adjoa Mary is Nana's wife. That is Nana Tikopo's wife. She also worked for Kwesi's wife as a nanny for 3 years. So Tikopo has been a driver for 13 years. The wife has been a nanny for 3 years. That's 36 months. Kwesi wants to travel with both Nana Tikopo and Adjoa Mary to the UK as one of the employees. How can they obtain a successful visa? I have three scenarios. Think about that. We're going to have our discussion, and when we come back, I'll bring these scenario and ask you these questions again and see how well you do about that. Apply as Chrissy's employees as they have worked for more than 12 months. Apply as a tourist to visit the UK, or Kwesi must show that he will pay them the minimum wage and also provide a contract of employment that complies with UK laws for their duration in the UK. Which one will be your correct answer? Think about it. I'll be right back. But when I come back, I'm going to go into that automatic route where you can get British nationality for your children. It's the Community and the Law, and brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we're talking about children this afternoon. We live on YouTube, we live on Facebook, and we have with us Lawyer Charles Asma from BWF Solicitors, who is going to help us discuss this topic: children and British nationality, a pathway to automatic citizenship, and how to navigate that process. So there are some steps to follow, and then we also have our definitional issues that we're going to go through. Lawyer Asma, children and British nationality. We know the society protects children and makes sure that the welfare of children is well catered for. Human rights, obviously, and all that. But is it that some children do not qualify for British nationality? Let us in on it.
Thank you very much. So today's conversation is about children's automatic citizenship in the UK. We are looking at different options, and we're going to navigate through those options and how to get to the end. So we're going to look at three pathways. I will kindly ask producer to show us the law underpinning this conversation. So we have a child born in the UK, and at the time the child was born, one of the parents was a British citizen or a settled person in the UK.
Now, when you say settled person, Does it mean that the person has indefinite
leave
to
to
remain?
remain or permanent residence in the UK.
Okay.
So that's the first point, born in the UK. We also have somebody born outside of the UK. And at the time the child was born, one of the parents was a British citizen. So this time British citizen, not settled.
Not settled. Okay.
And the next
so it has to be
outside,
one of the parents,
British citizen that is born outside after 1st of July 2006. After 1st of July 2006. So a child is born outside of the UK after 1st of July 2006 to a parent, is T, not TS, to a parent who is a British citizen. So this time there's no settlement, British citizenship. Now, so one parent. And that parent, so usually father, and that father was not married to the mother of that child.
Okay.
Not married. So in this case, the child is automatically British, and therefore we apply for passport for the child. We'll come to that bit.
Okay.
So that's the second pathway. The third pathway is adopting a child within the regulatory framework of adoption, what we call international adoption or the Hague Convention adoption. We generally call it convention adoption. So the child has been adopted after 1st of July 2006. So if you adopted a child after 1st of July 2006 and the child has become your child legally, then it's like having given birth to the child. After 2006.
So then the three pathways will be one, birth in the UK, and one of the parents is British or settled. Okay. Now, born outside of the UK from 1st of July 2006, and one of the parents is a British national.
This time, the father of the child is a British national.
So it has to be the father.
The father. And the father was not married
to the mother
of the child.
Okay. Then the third one is adopting a child after the 1st of July 2006. And
you being a British citizen.
Would a child being adopted, would that child have to be in the UK or outside of the UK?
So that it doesn't really matter.
Okay.
But usually if you're adopting a child, at the moment, most people adopt from abroad. Fine. Of course, they also adopt from
the UK.
But either way, adoption. So once you've adopted a child, the child has become your biological child, your legal child. Now, we have to make sure that the adoption process followed the Hague Convention adoption process, where you start from the UK and finish in the country where the child lives.
Okay.
Now, we're going to discuss each of the three pathways. So, producer, please show us the law, the British Nationality Act, 1981. It says British citizenship, acquisition after commencement. And here it says that acquisition by birth or adoption, acquisition by descent, acquisition by registration overseas, acquisition by... So today we are not looking at acquisition by registration. We are looking at acquisition by birth, adoption, so the descent will be the one outside, born abroad. So let's go to acquisition by birth or adoption. Please expand it for us. So section 1, subsection 1. A person born in the United Kingdom after the date of this law or in a qualifying territory. So there are some territories that are territories of the UK. And so those colonies, some of the colonies, not all of them, shall be a British citizen if at the time of the child birth, his father or mother is a British citizen or settled in the United Kingdom. So if you look at the first part of the law, what's the key word there? Key phrase. born
in
the
the United
UK.
Kingdom. Okay.
So born in the United Kingdom is vital to the conversation. So born in the UK after commencement, at the time of birth, one of the parents. So in this case, mother or father was a British citizen.
Okay.
Or settled status, then the child is automatically British. Because it says a child born shall be a British citizen. It didn't say shall become a British citizen.
Shall be.
Shall be. What means is that the child is delivered with the right of citizenship, provided the criteria are met. Then we are not going to go into 1A or 2 and so on and so forth. Because there are instances where a child is born and abandoned, somebody picks the child and all that. From the date of picking the child and making the child yours by going through the legal process, the child has become your child. Again, born in the UK, though not your biological child, but has become your child. Right. So if a child is born to you in the UK, we know that a child is automatically British. If a child is adopted by you in the UK or abroad, in this case, it doesn't really matter whether you are a man or a woman. Just like if the child was born, doesn't matter whether the parent was a father or mother. Either of them. The same way, if the child is adopted by a British citizen, whether male or female, the child takes after the citizenship right of that parent. So if that
British parent.
That British parent. So if that parent, let's say we have 2 British parents, then one of them can be the main adopter, quote unquote, the adoptive parent. Now, if one of them is a foreigner, then the adoptive parent will be the British citizen. Of course, by the papers, we'll know that it's obvious. So you can see. So instances could be that the couple are both same sex, but they want a child and they have adopted a child, going through the legal process. Once it is sealed, from the date of adoption or the day adoption certificate was granted or issued, the child takes after that parent.
Okay.
So if the parent is a British citizen, the child will be a British, or the word says shall be a British citizen.
Okay.
Whether abroad or
within
in the UK.
Okay.
In this case, if abroad, you apply for overseas passport. If in the UK, you apply for in-country passport for the child.
Okay.
We also look at, as we have said, so it's quite straightforward if the child was born in the UK, adopted in the UK. But if the child was born abroad, then we are looking at date the child was born. And it says if the child was born after the 1st of July 2006 and the criteria are met, one of the parents, British citizen, at the time of birth, they were not married. Okay. And so on and so forth. So what you do is apply for overseas British passport. For the child. So those are the nuances to this rule. Now let's go to the second part, which is section 2. Section 2, if you scroll down, it says that, if you go back maybe and take it from there. So 2, acquisition by descent. So a person born outside the UK, after the date,
yes,
shall be a British citizen if at the time of the child's birth, his father or mother is a British citizen otherwise than by descent, or is a British citizen and is serving outside the UK. So that's the armed forces.
Okay.
So A is about a child born. What would we mean by descent? We know that if my father is British and I was born abroad, and the law allows me to take after my father, then once I have it, my father has transferred his right to me. So if my father has transferred his right to me and I have become a British citizen,
Then you can
For my children,
you can transfer.
They must be born in the UK.
Oh,
because the law
so that is by descent.
By descent.
Okay.
Otherwise, if the child is born abroad, then I cannot second transfer because I have exhausted the transfer right.
So more or less, British citizenship is transferred only once.
If from abroad,
yeah,
by descent. So if you look at this one, it says otherwise done by descent. So if not by descent, what it means is that I was born in the UK, or I have acquired my citizenship through naturalization or registration, traveled abroad, living abroad, had a child abroad, come back to the UK, and I want my child to come. Because I did not acquire mine by descent, I can transfer to my child.
Okay.
Otherwise than by descent. Quite technical expression.
So if I try to simplify this, I have lived in the UK, had my indefinite leave to remain. I've applied for naturalization. I've been granted naturalization. I applied for the British passport. That completes the citizenship journey. Now I can transfer my citizenship to my child, but this my child, if he or she has a child, he cannot transfer that because he has had his British citizenship by descent.
So there will not be second transfer.
There will not be second transfer. So his children would have to apply.
So his children will have to, literally what it means is that if the person is a child and has been brought to the UK by virtue of becoming a citizen, then they have to make sure that they give birth to those children in the UK, so that a child will become British citizen. But the law says that a child born in the UK after commencement shall be a British citizen if one of the following applies: 1, British citizen of the father or mother, or settled status of the mother or the father.
But it doesn't have to be by descent.
How the father or the mother
acquired it. Okay.
But if the child is born abroad and you got it by descent, then you cannot go. You cannot go by that.
Yeah. Okay. So in that case, maybe I'm jumping the gun. In that case where they got it by descent, then they would have to possibly acquire a visa, bring the child in here, and register them for them to go through the process.
Good. So you can see that if it's a second transfer, then that beneficiary second transferee, the person transferring is transferor. The recipient is transferee. The second transferee is more or less a grandchild.
Yeah. So you can't give it to your grandchild. That is what it is. Okay.
Yeah. So that's a bit of simplification.
Okay.
All right. Right. So we are now going to look at the navigation process.
Okay.
Because it says the automatic citizenship for children and how to the pathway and how to navigate the process. So the first one, child born in the UK, and at the time of child's birth, mother or father is British citizen, or settled status, or has indefinite leave to remain. In this case, the child is British. So all I have to do is to apply for a British passport for the child.
Okay.
By making sure that I look at the passport registration process to get it done for that child. And the main thing here will be getting a referee who is a British citizen and can confirm that this is a child whom I know personally for this period, and I'm vouching for them to become a British citizen. Or no, I'm vouching for their passport application.
So then in this case, in the first scenario where born in the UK, one of the parents is a British citizen, you just have to apply for a passport for this young person, and you have to have somebody to be a referee for that. They know the person and they can vouch for the person to apply for a British passport.
So that is point 1.
That's point 1. Yeah.
It says that at the time of birth, father or mother was a British citizen or has settled status. So what do you have to prove? Now we'll go to the father or mother.
Okay.
What is the evidence that at the time of this child's birth? So we have to look at 2 documents. 1, birth certificate, to know the date of birth
of the child. Okay.
And 2, citizenship certificate of the mother or father, or indefinite leave to remain documentation for the mother or father
Mm-hmm.
to compare whether birth certificate date and the citizenship or indefinite date, one is before the other. Which one must come first? The father's status must come before the birth certificate date.
Okay.
If it's the other way around, then number one will not apply. You have to
Mm-hmm.
go to subsection 3, which talks about section 1(3), which says that then the child must be registered to become a British citizen. If still being a child, the mother or the father has become British or settled.
Okay. So to provide the evidence, the first thing you should check is the time that you had your naturalization granted. So
Yes.
your certificate and the date on it should be prior to first of
Prior to the date of birth of the child.
prior to the date of birth of the child.
Yes.
And this we're looking at beyond the 1st of July 2006. That's where the new law kicks in.
So it says that, so even this one says that a child born in the UK after convention, but obviously a child born in the UK after convention, most of this conversation will apply to children who qualify
Mm-hmm.
in most recent times from 2006 to today. But even after that, because it says that a child born after commencement would have been, for this law is 1981, was enacted in 1981,
Mm-hmm.
79, 80, 81. And therefore, after commencement would be any date from that date.
Oh, so I get it clear here. The commencement is a commencement of the law,
Yes.
not the time caveat within the law.
It says after commencement. So let's go back to the law. So it says after commencement. So it says that after commencement shall be. So commencement of what?
Mm-hmm.
Commencement of the law.
Okay.
And this is the nationality law that we are applying. So a child born outside the UK, a child born in the UK, of course, there are different parameters.
Mm-hmm.
And it says that after commencement. So we now know that after commencement would be, but if we are doing it today or post 2000, post 2000, 2006 coming, of course, most of these children will be talking about 2006 coming. But as long as the child is still a child, what it means is that if the child is more than 18
years
or 18 plus, so more than 17, then this will not apply to them. And if you do the calculation, you can see that children, so 18, 2024, 24, 86, so that's about 2006.
Mm-hmm.
So if you do the calculation carefully, so from all that part, what we are saying is that if the child after commencement has been born, and at the date of the child's birth, the father or the mother was, then automatically.
And it shall.
It shall.
Okay.
So the conversation is about automatic citizenship. Mm-hmm. So we are not even going to go into registration, where it is not automatic, and so I have to ask for it.
Okay.
So if a child is automatically a citizen, you have to apply for citizenship for the child.
No, because the child is already a citizen. Yeah.
So let's extend the conversation. Mm-hmm. A client has come to me to say that my child has been born this week. Mm-hmm. I had my indefinite leave to remain 2 weeks ago, and my child was born a week ago. That means child was born after mother has become settled.
Yeah.
Child doesn't have passport. He says shall be a British citizen. Passport is just an identity document, remember.
Mm-hmm. Yeah.
It doesn't tell somebody that a person. So what qualifies somebody to be a British citizen? The law.
The law. Okay.
So if the law says I'm a British citizen, it doesn't matter whether I have a passport or not. So if my child doesn't have a passport because I haven't done the passport or applied for the passport, it doesn't change my child's citizenship status. Mm-hmm. So we look at birth certificate and the date I applied my indefinite leave to remain. And now we can see that, oh, this child is automatically British. So when I'm applying for, I'm going to depend on this child for my regularization because I want to remain part of this.
So you need at least those two documents.
I'll provide the birth certificate which shows that I am the father or the mother, depending on who wants to apply for 2.5 on this, based on this child. So we have finished the conversation about the child. We are now transferring the right to a parent who wants something. But there will be a question on that, I'm sure.
Definitely,
that, our viewers are wondering, okay, so that's how. So what if I don't have passport? If you don't have passport, you can prove that this child is automatically British. Then all you have to do is explain in your cover letter that, or even if you don't want to write a cover letter, when you are applying for your 2.5, there is a box called additional information box. You explain that my child was born today. I got my indefinite leave to remain yesterday. The law says that if at the time my child was born, I have indefinite leave to remain, then my child shall be a British citizen. I therefore believe that my child is a British. You see, you are not writing legal thing. I therefore believe that my child is a British citizen. Because my child is a British citizen, I want to depend on my child as a qualifying parent to apply so that I can remain with my child for my child well-being sake.
Okay.
This is my child's birth certificate showing date of birth. This is my indefinite leave to remain document showing date I got it, that whatever I'm saying is true, and therefore consider my application. They will refuse it.
Now, let me get some clarification here. The person who's got an indefinite leave to remain doesn't need anything else but about looking for naturalization, maybe. But then the other parent that probably doesn't have anything would then depend on that child.
Yes.
And using the evidence of the other parent that's settled and the birth certificate of the child to say that
the child is a British
citizen, so I'm depending on that child to do that.
So the child shall be a British citizen, has become a British citizen by the operation
law
of
itself. Shall be.
Section 1.1. And therefore, my child, you are not quoting the law. You just say that I got my my indefinite yesterday. My child was born today. Birth certificate, indefinite leave to remain document. Therefore, I believe that my child is a British citizen. Full stop. I am a parent in the life of my child. My child lives with his or her mother, but I play a key role. This is the school documentation. This is the GP documentation. This is what the mother is saying. These are the pictures showing that I play a role. So you are proving you have direct access to your child. The law doesn't say add passport. Of course, identity of the child if you have it. But if you don't have it, then it's an operative word.
There are qualifying documents, obviously.
It's
not necessarily the passport.
It's automatic that your child is British. So whether you can prove it with the passport or you can't prove it with passport, it's a matter of inference from the fact of the documents available.
Okay. Well, if you just joined us, we're having a very lively discussion on children and British nationalization or nationality, if you want to put it that way. We're looking at the pathways. Lawyer Charles Asma, resource person from BWF Solicitors, is giving us all the three scenarios. One where the child is born in the UK and one of the parents must be settled or a British national. Two, the situation where the child is born outside of the UK. The father must be a British citizen. And then the child adopted, whether adopted here in the UK or outside of the UK, one of the parents must be a British citizen, and then you can depend on that. So we looked at the first scenario where the child was born here in the UK, and we using the time that one of the parents was settled and or become a British citizen and the birth certificate of the child to really prove that the child is British and that you can depend on that child for any application that you are putting through. This is the Community in the Law, and it's brought to you by BWF Solicitors. BWF Solicitors is located on the 4th floor of the House, 214 to 218 Tottenham High Road, Seven Sisters, North London. You can call them on 0208 493 7340. You can see the numbers at the bottom of your screen. There's an office for BWF Solicitors in Ghana, and the number is 0023355 589 5959 0023355 589 5959. Now, if you want to call BWF Solicitors anytime 24 hours round the clock. You can call on 077 127 61884. 077 127 61884. BWF solicitors, when it comes to any immigration application, trust them. When it comes to your settled status here in the UK and you want to have any clarification or put in any application, talk to BWF solicitors. When it comes to family matters, marriages, divorce, and what you can do with those situations, talk to BWF solicitors. When it comes to advice on employment and all the rest of it, talk to BWF solicitors. And I love it when Lawyer Charles Asma says that is the call of hope, the channel of hope. Talk to Lawyer Charles Asma anytime, any day. I'm going to put his number on the screen for you, and then you can call him directly and speak to him. But it's all under the auspices of BWF solicitors. Lawyer Charles Asma is 07947 63 60 37. 07947 63 60 37. He's right here with us and taking us through the various pathways to automatic citizenship and how we can navigate those pathways. So let's go to the second one. We've done the first one, that is the child born in the UK and one of the parents settled or a British national. Now, what about the child that was born outside of the UK, Uncle Charles?
Yes. So before we even go to the child born outside the UK, let's look at a child adopted.
Okay. All right. So then we can take that out of the way. That's fine.
So child adopted. So in this case, you need a child and you are not able to get it by yourself. Let me put it that way.
Mm-hmm.
So you have adopted. And of course, some people are very, very kind. So they will look at children who need help and give them the help and hope they need. So you've adopted a child. Now, once you, so if you look at, for example, section 1.2, it says a newborn infant, very important, a newborn infant after commencement is found abandoned in the United Kingdom shall, unless the contrary is shown, be deemed for the processes of subsection 1 to have been born in the United Kingdom after commencement. So here, if a child is found abandoned and you pick the child and the council allows you to look after the child by operation of adoption process, then the date the child was born will be the date the child was found.
Okay.
Because we don't know when the child was placed there.
Mm-hmm.
So it's very important. But most people will not find babies and therefore they have to go through the adoption process. So the adoption process, either you are adopting the child in the UK, you have to go through the UK adoption process. So you have to do it through the council in which you live. And of course, so you found a child in another borough. You live in a different borough. You speak to the borough in which you live and go through the adoption process to be able to have the child. Or the child lives in the same borough as you. You go through and you call the council or the borough and speak to the fostering unit, the fostering department, fostering and adoption department. So they'll show you the process. Once you go through and the certificate is issued to you, you have become the legal parent of that child. Then it will be that a child born in the UK to you, and then the law will apply as though the child has been born to you.
Okay.
Now, adoption abroad.
Okay.
So child born abroad, you are adopting the child from there. So we have the country of origin and the country the child is, or the country that is receiving the child. The country receiving the child will be where the child will live after adoption. The country of origin will be the country where the child lives. Both countries must show evidence that the proper process have been followed to have that transfer of the child or to have the child relocated. And it's all about avoiding child trafficking, safeguarding children, and making sure that children are protected from unscrupulous parents. In this case, what do? There's what we call Hague Convention or Convention Adoption. The Convention Adoption follows the UN Convention process. So there are countries that have signed and ratified the arrangement. Some of the countries, the UK has not listed them. Some of the countries have not signed the treaty. They are not members, but they have approved the process. So UK do not have those countries that are not members on its list.
Okay.
Even though UN may have the countries as members, some of the countries are in italics and some of them are in bold. So the ones in italics, they are saying that they are not members to the convention, but they have signed the convention agreement. So what do? What you have to do is that you start from UK, get the council to go through the process of adopting that child from abroad. Because the child doesn't live in the UK, the council has to liaise with the social welfare department of the country where the child lives, so that they also take the assessment process up and make sure that it's done and the child is cleared. Once safeguarding issues are cleared, a court of competent jurisdiction will issue adoption order or certificate to that child.
Okay.
So you can see that we now have two, one from the home country and one from the adopted country, so to speak, where the child is going to live. Or if it's UK, a child going to the UK. So once it's cleared, then you can see that this is fully fledged adoption process.
Okay.
So if it's fully fledged adoption process, you have to make sure that both countries have approved it. If where the child lives approved it, then the country must confirm that they have followed the UN convention, they are members or they have signed. Usually UK will say they have to be both members and signed. But if you really want to fight them, you can say that if you have accepted this country to be a signatory to the convention, accepting that whatever processes that they need to follow to give certificate of adoption to the child has been followed, and whether you have it on your list, the country list or not, you should accept it. But that is you fighting them. Otherwise, start from UK, ending in the country where the child lives, and make sure that it's full and it's complete. So once that happens, the date of adoption, the child has become your child. Then child born outside, provision will kick in. Then the child will be a British citizen. In this case, all you need to do is to apply for a British passport for the child.
For the child outside of the UK.
Outside of the UK, because the child doesn't live in the UK, so you cannot apply in country. You have to apply out of country, which is called overseas passport application. So what do you need? Evidence that the child is your child. You also have to show that the child has lived with you for about 12 months before the date of, or up to the date of adoption, has lived with you. So was living with you
before you put in that legal process.
Exactly. Okay. Otherwise, it will appear as if it's been done for the purpose of
acquiring the citizenship.
So you have to show evidence of becoming.
So then you should prove that the child has been part of your life,
or
at
least
a year,
part of
the child's life at least for a year.
For a year,
okay,
12 months, so to speak. Once that happens, you have your adoption certificate, which replaces birth certificate.
Okay.
Your own nationality document. Then evidence that you've lived with that child for that period. Evidence that the processes were followed, and then you put in the application, adding all that. Of course, there will be some photos to show that the child being part of your life, you have progressive photo evidence, and also even after the adoption, photo evidence. And the fact that if they are part of your life, then you were going to that country to visit them often.
Okay.
All that pieces of evidence of traveling there must be added. Then adoption will make it possible for the child to become automatic citizen based on yours. So if you do the adoption, if you do that birth in the UK, the third one is born outside
of the UK
to a British citizen but at the time of birth, parents were not, father was not married to the,
But the father was British.
the father is British. In this case, it is the father applying for passport for the child, not the mother.
Okay.
So in this case, there will be interview process. So bear in mind that you'll be called to be interviewed. So if they are calling you to interview you, of course, you have to make sure that.
So what kind of questions will be asked during the interview? I have my child. I am applying for a passport for the child. The child was born post 2006, 1st of July. I had my British nationality prior to the child being born. What question again would they ask me?
So, conception evidence. Sometimes they even ask you.
Conception
Yeah,
evidence?
sometimes they even ask you to provide photographic evidence, scan images of the pregnancy, the fetus.
Well, why would they want to do that?
But they want proof that what you are saying is the
true.
case. So, and it is your case to prove. So just give them everything they ask for, including evidence that the child has been part of you from birth to the date you put in the application. Maybe the child is 17 years.
Mhm.
You are putting the application. What shows that the child was born to you, has been part and parcel of you, and so on and so forth.
There are fathers who, unfortunately, probably were not even given information that the child is yours. And it comes to your knowledge that this child who is, say, 10 years old is my child. You go through all the rigors, name the child, get DNA done to prove that you are the father and everything. In that case, what evidence would I have to give? If you're talking about evidence of conception, I didn't know. I got to know of this child after 10 years. What do I do?
Right. I mean, you got to know after 10 years, and you have done at least paternity test. It confirms that this is your child.
Mm-hmm.
So then at that point, it becomes a matter of argument with them, because you don't have objective evidence. So it will be those subjective representations. Then they have to make the assessment. So that is one. Overseas passport applications can be quite tedious.
Okay.
So we always advise that take your time and get it done right. Again, the child must provide, or you must provide two passport photos within 3 months. Within 3 months to the date of application. Okay. So current passport photos, and it has to come from the country. You can, of course, the child doesn't live in the UK, so you will get it. And if the application is being done in the UK for the child, you post it to the UK so that they have it to be able to put all together and post it to them. Overseas passport applications are not online.
Okay.
They are
paper
application. So you have to fill the form, add your document, again, get referees to sign, and so on and so forth. So if the referee lives abroad, who knows the child? You have to get the referee to sign. One of the, of course, the referees must be a British citizen, because you need passport for this child. If the child is more than 13 years, 13 plus, they have to sign the back of the passport.
The child itself has to sign.
But if the child is younger than the age we have stated, then the father or the mother would have to sign. But it's usually the father who has the citizenship right and giving it to the child. Who and most of the time it might be that the case that the child lives with the mother, but the father didn't marry the mother, and so this is my child, lives with the mother. This is not about the mother, but it's about my child. So in our instances where the mother will be invited to attend to interview, and the father will also be invited to interview.
Would that be done separately?
That will be done at the same time. So if I said the same time, they won't sit together. Right? So at the same time by different people.
Okay.
Yeah. And you know why?
Well, just to see if your stories will cover it.
Exactly. So that you don't share the questions after yours. Yeah. So at the same time. But it's usually online, whether by Zoom or telephone. interview. Right. So we can see that for overseas passport application, photos, everything about the child's father who is applying for this child. Again, DNA, if the child is, if you want to prove that this is your child, because there are instances where the child birth certificate is recent. So what shows that this is your child? DNA will be the only plausible evidence to add to the passport. Someone will say, well, but DNA is not compulsory. It is not compulsory. However, that is the only way at this critical point to prove that this is your child, and therefore you are transferring your citizenship rights to the child.
You're live with us on BW TV, and we coming your way courtesy BWF Solicitors. Our resource person and guest this afternoon is Lawyer Charles Asma, a solicitor at BWF Solicitors, and he's taking us through the three pathways through which we can have British nationality automatically for our young children and how we navigate the process. And he's taking us through that. We need evidence of your citizenship, evidence of the birth of the child as the birth certificate, and adoption certificate, of course, where you gained legal parentship of the child you are talking about. I know you have your questions. I know you have your issues. You can send us via text 0739920848, or you can call us in on 0208 493 7345. 0208 493 7345. And remember, I set out a question and I want you to answer it when we get to the comment section. So get ready and get your questions in. Lawyer Charles Asma is here and he's going to help us with that. First of all, let me say that we have people following us live on Facebook, we have people following us live on YouTube and all the social media platforms. Kwame Joe has a first question. Hello, Requense Charles. I was refused settled status as an EU national due to not being able to provide all evidence. What will happen if my pre-settled status expires? Uncle Charles.
Okay. Not refused because I did not provide all evidence. Full stop. Now, what did you do about the refusal? That's a question I will ask. Because if they refused you and you accepted and you didn't do anything and it expires, what do you do?
Okay. You'd have to provide the evidence.
Unless, of course,
further information you were asked to provide.
So, unless, of course, this person is saying that, all right, because so EU applications, there are a lot of flexibilities. Unlike 2.5, which when it expires, you have become illegal, and the EU, once your visa expires, you are not illegal because you are still living in the UK as a family member of a British national exercising treaty rights in the UK. And therefore, the free movement of persons will apply to you as a family member. So if you decide not to do anything and you go ahead to do something, you have to then show that you have met the residence test and you now have all the evidence. Of course, what then happens is that you will not be able to work because the employer may ask for evidence that your thing has expired. Have you renewed it? So in terms of job, you may be in difficulty. But in terms of your citizenship right, you can put in another application and this time provide all the necessary documentations to prove that you meet the requirement for either indefinite, of course, that will be indefinite or settled status. So EU 11 says that if you lived in the UK for 5 years and that if you are retaining your right, your partner is dead or you have divorced, or if it's a case that you have divorced, provide divorce certificate. If it's a case of death, provide death certificate. The same applies to children if the parent is dead. With children, it's not about marriage, so you cannot provide divorce certificate. And there's no cancelled, once we have cancelled marriage certificate replaced by divorce certificate, We don't have cancelled birth certificate, which will be replaced with anything. So when it comes to children, it is your your parent death certificate that will show that you have retained your right. If you haven't retained a right, then you have to prove that you meet the requirement. So if you still cannot provide the evidence, then you have to keep waiting. Your job will be at risk. Your ability to rent in the UK will be at risk, and so on and so forth. But even that, the law says that people cannot be punished. People with UU rights cannot be punished because they don't have this or they don't have that. Their rights are automatic in a way, and therefore, by extension, you can deal with your employer. But for the employer, they are also under the law. You cannot hire illegal migrants, and therefore, at the point where you are illegal, your employer has the right to say you can't work, even though the UK has the right to let you stay. The employer doesn't have the duty to keep you in that employment. So what do? Apply again. Make sure this time you have all the evidence.
Okay. Yes, you can keep your questions coming through. As I said, the lines are active. 0208-493-7345, or you can put your questions in the comment section down below on both Facebook and YouTube, and we will deal with that. Good morning, lawyer. It's afternoon anyway. If one is in debt and have debit arrangement order with their debtors, what effect will they have on their nationality application?
We answered this question the last time, but we'll answer again. There's no effect. There's no effect on your nationality application. It doesn't fall under suitability criteria.
Okay. Right. Yeah, keep them coming through 0208-493-7345. Please, can someone apply for 2.5 years as parent of a child with settled status through their EU mother who is living here in the UK?
So the law says that a child who has settled status is a qualifying child. And therefore, you, the parent, has become a qualifying parent. So please, can someone apply for 2.5 based on their qualifying child? The answer is yes. Even if the child has pre-settled 5 years EU, they are still qualifying child, and you can still apply.
Okay, we're live on Facebook, we're live on YouTube. Get your questions coming through. This is the time to do that. But remember, I had that scenario, Nana Kwesi Etikopo and his wife who have been working for another person who wants to bring them to the UK. Adwa Mary is Nana's wife, as I said. She's also worked for Kwesi's wife as a nanny for 3 years. Now, Kwesi Cashman wants to travel with both Nana Etikopo and Adwa Mary to the UK as one of their his employees. How can they obtain a successful visa? One of the three: apply as Kwesi's employees, as they have worked for more than 12 months. Apply as a tourist to visit the UK. Or 3, Kwesi must show that he will pay them the minimum wage and also provide a contract of employment that complies with UK laws for their duration in the UK. What is your answer? Think about it, and when we come back later on in the program, we'll be looking at that. But in the meantime, you get your questions coming through 0208-493-7345, or send a text to 07399-208-468. Okay, now let's take this. In relation to the above question regarding the EU national settlement refusal, is it not going to be automatically reviewed for 2 years? Alex, I don't know if it is in relation to the previous question or something else.
Yeah, that's why I said that even if it's refused, you are okay in terms of living in the UK. Remember, I said that. I said that the problem will be with employment, because the employer will not say, but of course, will it not be renewed? Once it's renewed, you are okay. But if it's not renewed, you have trouble with the employer. But you won't have trouble with your residence. So that's the difference. And it will be renewed. But if it hasn't been renewed, what do? You wait for the renewal. So that time,
hello, this is BT Call My
does the person do?
Okay. Yes, so you can call us on 0208-493-7345. Should a husband take care of his wife during separation? Elizabeth is asking.
That's a choice. I mean, after all, there are philanthropists in the world who even help enemies. And therefore, and mind you, separation is a period of cooling off. And therefore, people come back after separation. But if your separation means divorce, then I think this person is talking about arrangement, financial settlement after divorce. So under family law and also Matrimonial Causes Act, 1973. So under the family law, UK, 1996, itself will tell you that once you have gone through separation and divorce proceedings have been started and ended, you have your divorce certificate. The next stage will be how to deal with your finances. Within the finances, there are two spectrums. We have what we call a point where both parties are going their separate ways. What we call it clean break. So if it's a clean break, you don't have obligation. But if it's not a clean break, you have obligation to look after her. How do we get clean break? Clean break is where you say that after separation, we go our separate ways, or after divorce, we go our separate ways, each one for themselves, God for us all. But the children, we will come together to decide how to look after them. So I'll be looking after my children, but not my ex-wife. But if there's no order for clean break, or you haven't sought clean break, then it will be your responsibility to look after them because you have made them poor or impoverished. And so if you leave them, how did they start all over again? Because they were looking after their children. And maybe because of you, they didn't assume any career. So if you live with all the wealth you've created because she freed time for you to upgrade yourself and be better, then you have to stay wherever you are and make money available for her. So do you have to look after the person? Yes, depending on whether there's a clean break or no clean break.
Now, I'm thinking of a scenario, maybe before we go on to the next question, thinking of a scenario where people have been separated for more than 10 years and there hasn't been any effort to come back together. Well, would the law look at this as divorce because there hasn't been any effort for them to come back for over 10 years?
Yes, so you have to end the process.
Who has to end?
One of them. If you know that there's no, so we call it irretrievable breakdown of the marriage.
Okay.
So if the marriage is irretrievably, the law doesn't say the marriage is broken down. It says it's broken down beyond repairs, gotten to a point of no return. So if there's point of no return and you've reached there, what are you waiting for? Finalize it to have evidence of separation.
Okay.
Because if there's no evidence of divorce, then the law sees both of you as legally married.
Right. Okay. Yes. Your content, your questions and your questions, I should say, is ready for us to look at. Okay. Now, Baggio Nike. I hope I got your name right. Hello. My question is: in case someone has been given 60 days to look for a new sponsor, can the person apply for further leave to remain? You've been given 60 days to look for a new sponsor, or to look for new sponsorship, as is put it. Can that person apply for further leave to remain in the country? I came in with a sponsor. Maybe the person's sponsorship is cancelled. I still have 60 days to sort myself out. Can I apply for extension?
So the 60 days is for a reason. It's for you to decide whether to stay on by doing something or leave without doing anything. So if you decide to stay on to do something, then within those 60 days, make sure that you switch to something else. Either you switch to worker route again, or you switch to family life, family route. So family route means that you have a child who is a qualifying child and you are depending on this child to apply for family leave to remain. Within the 60 days, you can switch. Within the 60 days, if you find another employer or your employer reinstates because they have been reinstated, then you can get you can make another application under the skilled worker route. Or within 60 days, if you have remarried or you have married, depending on your circumstance, then you can apply again to remain in the UK with your wife or husband. However, if you were married and because of this situation, let's say you were married, you divorced your your spouse, and you are if remarried, then so you've divorced, remarried, applying to remain with a new wife. The question is, what happened to the rights, so the immigration status you had with the old spouse?
Mm-hmm.
Home Office are aware that they've taken it from you. Could they conclude that you are rushing to move because of the 60 days they've given you?
Mm.
Is it possible for them to conclude commonsensically?
Yeah, it would make sense.
It will make sense. And
It would make
therefore,
sense.
they will make that inference that, hang on, look at the timing. Is it possible that this is it? But there's no law to say that you cannot make that application. The worst case scenario is that they will refuse it and you go to court and fight it there. Because that is where we go to settle scores. So can I do something within 60 days? Yes, you can.
Yes, you can do something within 60 days. As well as I said, sometimes you'd have to push and test the laws with all that. We have one question here. A quick question, please. I recently got my further leave to remain fee waiver rejected, and within given 10 days, I submitted a paid visa application within from UK, and my biometrics are scheduled for September. In the meantime, if my employer requests for an ECS check, does it result in positive outcome, or ECS shows positive only after my biometrics are given? Sri Sai Teja Malipedi sends in that question, lawyer.
Yes, that will result in positive ECS outcome. Even if it's negative or inconclusive, like yes, or no, like there's nothing showing, then you can still challenge them. Because by the operation of the law, your visa was about to expire. You applied for a fee waiver, which says that if you made a fee waiver application before the visa expired, then you are within. If you are within and the fee waiver is rejected, you are given 10 days to still stay within and apply by paying the money. You are within the 10 days. You have applied and paid, submitted before the 10 days ended. What it means is that the 10 days has become the expiry date for the visa itself. So even though the visa has expired technically, in principle, technically it hasn't expired. For that 10 days, the fee waiver period delayed the expiration. And the new 10 days you have been given has delayed the expiration. So your job is do it before the 10 days is over. Our friend did it, so she's okay. If the ECS comes and it is negative, call us or challenge them.
Well, that's the assurance you are always giving when you deal with BWF solicitors. They are on the number 0208 493 7340, 0208 493 7340, or the emergency 077 127 61884. Lawyer Charles Asma, resource person and guest this afternoon, is a solicitor of BWF solicitors, and you can also call him directly on 07947 63 60 37. 07947 63 60 37. Now, at this point in time, we are going to take one quick break, and when we come back, we're going to look at our quiz and then have a lawyer explain what the correct answer will be. Then we'll draw the curtains down. It's been the community and the law, and we've been discussing children and British nationality, a pathway to automatic citizenship, and how to navigate those processes. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, we are on the final stretch of today's program, The Community and the Law, live on BWTV, and we come your way courtesy of BWF Solicitors. What if Baju Neki comes up with a follow-up question? What if I decide to switch to study route? Lawyer, I think it is the one that was asking about the 60 days notice given, and he wanted to do something within that notice period. What if he decided to switch from the work visa route to the student one?
Right. So if you now want to study, you go back to your country and apply for student visa and come back.
Well, Nike or Nike, it's quite straightforward like that. So, well, if you're ready, get your answers, get into text them to us on 0739920848, either on WhatsApp or text message, or you put that in the comment section below. Now, the answer is 1, 2, or 3. Okay, Charles Emery is number 1. Nana Tikopo is a driver at Kwesi Cashman's house in Accra, in Ghana. He has worked for Kwesi's family for 13 months. Adra Mary is Nana's wife. She has also worked for Kwesi's wife as a nanny for 3 years. Kwesi wants to travel with both of them to the UK as one of his employees. How can they obtain a successful visa? Apply as Kwesi's employees as they have worked for more than 12 months. That's what Charles Emery is saying. Or is it to apply as a tourist to visit the UK? Joseph Isaiah is saying it's number 3, which is Kwesi's must show that he will pay them the minimum wage and also provide a contract of employment that complies with the UK laws. Yeah, our team says it's number 3. Who else? Let's see what else we have. Tamat Bangura says it's number 3. Kwesi must show that he will pay them the minimum wage and also provide a contract of employment that complies with UK laws for the duration of their stay in the UK. Kofi Nyako thinks it's number 1, that is apply as Kwesi's employees as they have worked for more than 12 months. Stephen Amankwa says number 2, apply as a tourist to visit the UK. Who else do we have? Let's see. Baju Nike says number 3, Kwesi must show that he will pay them the minimum wage and also provide a contract of employment that complies with UK laws for the duration of their stay in the UK. Lawyer Charles Asma, I think I'll go with number. Okay, I'll leave it until you explain. What would be the right answer? The scenario, and I think it is based on a nugget. Maybe for lawyer's sake, I will go back to the nugget again. That this domestic worker visa admits domestic staff working in a private household to enter the UK and continue the employment in the UK for up to 6 months. This visa is suitable for domestic workers in circumstances where their employer or the employer's family members do not intend to remain in the UK for more than 6 months. What areas does this law cover? Cleaners, chauffeurs, chefs, personal carers, nannies. These services must be for the employer or their family members. Immigration rules appendix, domestic workers in a private household. Lawyer, over to you.
Thank you very much. So we are told that the provision under appendix domestic worker says that because the domestic worker is a worker and they are traveling to the UK to serve their master or the employer for 6 months, they have to show that they have contracts based on which they can work in the UK. Because they are coming to work in the UK, they must have the contract that complies with UK laws. It wouldn't be their own country contract. And one of the key things is that the salary quoted in the contract must reflect the law governing salaries in the UK, which is the National Minimum Wages Act 1998. The contract must comply with the Human Rights Act, the Employment Rights Act 1996, Section 1, which says that the name of the employee, the name of the employer, place of employment, contract duration and all that, salary and all that. But because this time the person is traveling to work in the UK, they have to amend the contract to reflect UK law so that it will be that it's a contract that suits UK employment law. And once that is done, the person can apply. Therefore, they must show that 3 applies.
So number 3 applies. Chrissy must show that he will pay them the minimum wage and also provide a contract of employment that complies with the UK laws for their duration in the UK. I think I see some strategy in here. But you know what? Call BWF solicitors on 0208 493 7340 or speak to lawyer Charles Asma directly and he will help you look at what I am thinking of. The answer to this Swiss test, to your knowledge, is number 3. There must be a written employment contract in the form set out in Appendix Domestic Worker Statement of the Immigration Rules. The template contract covers the likes of duration of employment, employees' duties, working hours, holidays, that the employer must pay for the employee's travel to the UK, pay visa fees, and the rest, that the employer must provide accommodation, that the employer cannot keep the employer's or the employee's passport. The contract must also confirm that the applicant will be paid in accordance with the National Minimum Wage Act of 1998 and any regulations made under the Act. For further details, contact BWF Solicitors 0208 493 7340. Well, time for us to draw the curtains down. The program has been a very exciting and educative one, and I would, as tradition demands, ask lawyer Charles Asma to do a brief summary of what we have discussed this afternoon before I say my thank yous and goodbye.
So, viewers and listeners, today we've covered a crucial point that children that meet the British Nationality Act 1981 law have automatic citizenship in the UK. In that they were born in the UK, they were still children, and that at the time of their birth, their mother or father was a British citizen or has indefinite leave to remain in the UK. What they have to do is to apply for passport. The next is that the child has been adopted in the UK or abroad, and that they followed adoption process carefully, and that meet the UN standard, and that the child has become their legal child. On that basis, having adopted a child after the citizenship of that father or mother or indefinite leave to remain right of either of them, the child has become a British citizen. All you have to do is again apply for passport for that child. We also looked at the fact that a child born outside the UK, in this case, after commencement, so from 1st of July 2006, you have to show that this is still a child and that the mother or father was not married to the mother and father were not married at the time of the child's birth, and you have evidence to prove that this is your mother, your father, and that you have evidence to prove that the child was born to you, the father, and you have evidence to prove that you are in the life of the child. Or once all these are proven, indeed your child has become your child, and so you can apply for overseas passport for the child, British overseas passport. We call it overseas passport because you cannot do it in country and it is by paper. You provide all the necessary evidence and the passport office will consider, call for interview, and when the interview is satisfactory, the child will be issued with a British passport. If after this you need more, please do not hesitate to contact. Thank you.
Do not hesitate to contact and do not hesitate to come back with us for another edition of The Community and the Law, same time next week on the same platform. YouTube, Facebook, both BWF Solicitors platforms and BW TV platform. On behalf of the production team, I want to say thank you so very much. Those of you who had time to stay with us all throughout the 2 hours that we had with you, and those of you who have picked up to share the link, we want to say thank you so very much. Do that again same time next week. On behalf of Sheila and Krempatno Dudu, and also on behalf of Professor Adair, my studio director and producer, I want to say thank you to BWF Solicitors, and to you out there, thank you so very much. I want to see you again same time next week. Until then, be good.